Appreciate everybody being here. My name is Jimmy Soni. I've been given the task of moderating this panel, which is, I realized this morning, I was like, this is a real chagrin to my Indian immigrant mother, because I didn't go to law school, and this is like one of those moments you'd be like, you really should have gone to law school. You know, everything would have been better if you didn't speechwrite and write books. But no, seriously, appreciate everybody being here, and looking forward to a rich and lively discussion. We have two people who I admire their writing on this subject. They've covered every part of it for many, many years, and look forward to hearing what they have to say. Ilya Shapiro is the Director of Constitutional Studies at the Manhattan Institute, and Devin Westhill, to my left, is the President and General Counsel for the Center for Educational Opportunity. And our panel title is...
I always love, Devin, how you're the CEO of CEO.
Right. The panel title is The Next Wave of Affirmative Action Legislation, coming in the wake of the Supreme Court's decision this summer. But I thought the place to start, particularly because there's a second audience on YouTube that is gonna drive up the video views on this, was actually, Devin, if you could just start by kind of like setting the table, what happened this summer, and then we can get into how we think about it, what the implications are, and what's going to happen next.
Well, really appreciate that. This is a fun topic that I talk about with increasing frequency after June, when the Supreme Court effectively prohibited the last vestige of institutional or systemic, whatever we want to call it, racial discrimination in America in college admissions. What the Supreme Court said was that the license that it gave over the course of a number of decades to consider race in admitting students to colleges and universities is now over. And I'm optimistic that at least the use of overt racial preferences in selecting students for colleges and admissions is actually over. I think there's going to be a fair amount of discussion that we can get into about how schools are still going to attempt to racially diversify their campuses. They are committed to racial diversity, I hope, in some other ways as well. I'm not, against diversity completely, but we're going to test the boundaries of exactly how far the Supreme Court's decision goes. What the Supreme Court said in June in the Students for Fair Admissions versus Harvard and versus University of North Carolina decision was Harvard University and the University of North Carolina were never doing affirmative action the way in which the court approved in the Grutter case of 2003 for the educational benefits of a diverse student body. They were never doing it right. One of my criticisms of the decision from June is that they didn't just outright overturn Grutter. Although in concurrence, Justice Thomas says, for all intents and purposes, Grutter's overturned. I do believe that the majority in the opinion did not do so in so many words. They said you weren't doing it right. Right? The way in which you're doing this has no sort of objective, measurable way in which a judge can determine whether or not you're achieving, for example, creating innovation, for example, by having people of different racial categories together. You were using race in a way that was negative. That's impermissible. You had no endpoint, right, on when this was going to finally be over. And quite frankly, about a year ago when I listened to 5 hours of oral argument on this, there were no good answers to the question over and over again, when is this going to end? The advocates for racial preferences in admissions, including the Solicitor General of the United States, sort of, in my view, resembled Jell-O when you try to nail it to the wall on this issue. Basically, what they were saying was that we're going to have racial preferences in perpetuity. The Supreme Court said you can't do that. And then finally, you're stereotyping people. All of these things, 4 of these things that you're supposed to deal with in a way that satisfies constitutional muster, you didn't do. You're never doing it right. Therefore, Harvard University, University of North Carolina, and every other college and university, a selective college and university in the country that uses race preferences in this way, your days are done.
To put a finer point on it, even though the court did not say the magic words, we're overturning Grutter or Bakke, the 1978 case that started the modern use of racial preferences in higher education, they effectively did do that because I, for one, and maybe there are people smarter than me, I see no way, following the logic of the Supreme Court's ruling, that there can be a system in place that uses race and still complies with the SFFA ruling. I mean, you can engage in sophistry and word games and all of this, and we'll discuss what the future litigation is. But when the court says you can't put in through other means, whether diversity statements, which are now going to be known as adversity statements, or other proxies, the same regime that we're outlining now. I just don't see. They're going to try, and we're going to have more litigation over different things, and in other contexts. Although if the court is sincere, then the same logic will apply for employment and contracting and other legal spaces. But I don't think there's a way to reconcile, the statements that racial discrimination is wrong, period. These kind of very bottom line, unequivocal statements in the majority opinion with any type of system that uses race qua race for doling out government benefits.
So I do want to get into some of the ways that colleges and universities have responded. I think in some commentary, Devin, that I'd seen from you, you were actually heartened to see that UNC had kind of accepted the decision, realized that it had spent tens of millions in litigation, understood that it needed to honor what the court had laid down. At the same time, and again, I'm not a scholar on this, I thought that Harvard's decision to now make mandatory an essay about how an applicant contributes to inclusiveness or diversity, whatever the word was actually a bit of a sort of thumbing their nose at the court, that they're trying to achieve this by other means. I'm curious for both of your take on this. I think Ilya's line was the opponents of this, I was paraphrasing, but the opponents of this will not go quietly into the night. I'm curious for how you think, what does the landscape look like today at colleges and universities, and how are they trying to subvert the court's will?
So let me start with your initial point, which is the way in which the University of North Carolina at Chapel Hill, where I have one of my degrees.
At the Duke, I won't hold it against you.
And they're, okay, go Heels. Who was also sued, right? They're sued in this litigation over their admissions practices. How they've responded after the Supreme Court's decision, I think, in a very magnanimous way. They basically came out and said, look, we thought this thing that we were doing was really good. We thought we were on the right side of things. The court let us know that despite the fact that we gave it our best shot, our best arguments, we thought we were doing the right thing. We spent millions of dollars defending this thing. And we were wrong. We have to have some humility, and turning the page on this. And quite frankly, not only are we not going to do this in admissions now, choosing people based on their race, we're not going to do this in hiring. We're not going to have DEI statements and so forth at our school. We're really going to pivot away from this at this point. I think from sort of legal liability standpoint, that's a right way to go about things, but it's also from a moral standpoint, the right way to go about things. And I'm very happy that my alma mater has done that. I look forward to continuing to follow their really good work and leading the way here. Look, at the end of the day, and I've said this, I said this before the decisions came out, there's going to be evasion, right? These schools are committed to diversity. One of the ways in which they're committed to diversity is making sure that on their campuses they have, the rainbow of colors of skin, that make them happy. And they're going to think about ways in which they can get around this. And, I think even worse in the schools trying to think about how they're going to get around this is the Biden administration giving them advice and guidance on how they should do that, right? What we should want from our government, and a wise man once said elections have consequences, is to enforce our civil rights laws, enforce our anti-discrimination laws, enforce equal protection for everybody in this country. The current administration is not doing that. In fact, they're trying to figure out ways where schools can rejigger their admissions to get around the Supreme Court decision. I think there's a problem with separation of powers. I could go on and on about a number of other problems that I see here, but we see schools doing that. We see the Biden administration supporting them in doing that.
Well, look, we're having a bit of a replay of what happened with Brown versus Board, which did not desegregate the country overnight. It took lots more litigation. It ultimately took the Civil Rights Act. And here there's also massive resistance of various kinds. And you have, deans and presidents on record as saying, just don't write anything down. Because there's going to be lawsuits, and they're going to be discovery-heavy lawsuits. That is to prove the case I mean, if the percentages of the racial balancing that all these schools have been engaged in remain the same 5-10 years from now as they were this past year, then that's prima facie evidence that nothing has changed, that they're accomplishing the same thing through other means. So they're going to have heavy discovery to figure out exactly what is going on, and there will be lawsuits about that. Now, if schools were operating in good faith, and they didn't want to go so far as UNC and just embrace the new colorblind reality, and they said, well, we still want to give a leg up to those who are disadvantaged. Some people talk about socioeconomic benefits. That still harkens to me to a kind of mechanical adding points artificially and kind of automatically without taking into account the individual, which again goes against the explicit instruction of the Supreme Court. But there can be recruitment. I mean, I think it's a noble idea to identify diamonds in the rough, kids with lots of potential that might benefit tremendously from going to one of these institutions and potentially have a higher potential delta, higher potential change in their learning and their knowledge and their academic contribution than someone who's already achieved a lot but is kind of topping out, as it were. That's great. How you do that, I don't know. I'm not an education expert, although now I am on a board of trustees at Florida Polytechnic University. 2 weeks ago, Governor DeSantis appointed me. Not with the diversity on the board. I'm the non-STEM member there. But anyway, I think there are good faith ways to experiment with bringing people together of different backgrounds, what have you. But the question for colleges is different than the question for law schools or medical schools or any other thing. And so the devil really is going to be in the details. I'm not very much a practicing lawyer, although I play one on TV. But this still, there's going to be a lot of billable hours in the suing of higher education.
So one of the things I wanted to dive into, Devin, is your organization's research. Some research was actually published after the decision about the University of Maryland, and some of the data and insights that come from that and how they shape your understanding of what the landscape is going to be. If you could just talk about that, I found it interesting. It's obviously, it's not the only school where you found this evidence about how these policies are counterproductive, but it was pretty telling, and the fact that it came in the wake of the court's decision.
Well, sir, first of all, let me correct the record. I am the president and general counsel of the Center for Equal Opportunity, not educational opportunity, although that's encompassed in equal opportunity. So if you want to learn more about what my organization has done, look for Center for or Google Center for Equal Opportunity or DuckDuckGo it. I'm not sure what people are doing these days, but in any event, my organization for almost 30 years now, it's been around that long. A lot of people don't know about it who are interested in the space, but it's been around almost 30 years now. And one of the things that we've done as our core programming is to FOIA information, data from schools on their admissions practices. Before the decision came down, we asked for the admissions data at the University of Maryland College Park. We got that information back. One of the really, really smart people that works for us that can do data regression analysis and so forth was able to control for certain factors and figure out to what extent race and ethnicity played in the admissions practices at the University of Maryland. What we found, which is not unusual in the 80 plus studies that we've done over the course of 30 years, is that Black and Latino students got massive preferences to be admitted to the University of Maryland prior to the June decision outlawing this practice. Again, this is something that we've seen over and over and over again. Our studies have made it into Supreme Court briefs to help explain that this is a real thing. It's really happening. Here's the data to support that. But also, it's made it into the houses of folks around the country in the court of public opinion, explaining that this is actually a real phenomenon that we're dealing with. One of the things that I thought was so interesting about the study, although we've seen it many, many times before, was the extent to which black students, we got this information as well, actually are disadvantaged really by getting massive preferences to go to the school, right? They end up being mismatched, and we saw this in the data. The data bared out that despite the fact that black students were admitted at 3 times more likely to be admitted than white students, they had the lowest of all race and ethnicities 6-year graduation rate. So it was not doing them any favors to get this massive preference. And it's one of the things that I like to talk about when we discuss race preferences is, I think the folks who are most harmed are really the people who are folks, if I'm being charitable, folks are trying to help. And that's a real problem, not from a legal standpoint, but from sort of a policy and a moral standpoint. And we ought to be very careful about how, if we still want to help the disadvantaged, we do that. I'm not against, for example, as Ilya suggested, moving to something where, there's some preference, some small preference or something for poor students who are diamonds in the rough, or some socioeconomic considerations or something of that nature. What I am against is, again, implementing massive preferences where students are going to be placed in an environment that are not academically prepared for, and we see the same sorts of things. Dropout rates being disproportionately high for students who are not prepared, or changing their majors from hard majors like physics to soft majors like sociology, and seeing the same sort of thing where these students could have been the next engineers, next doctors, and so forth, but end up with these soft major degrees, and in something that they weren't passionate or interested in, just to survive the curriculum. So.
Ilya, just shifting gears a bit, I was hoping you could call it grade the squishiness of the opinion. How much room did the court leave for colleges and universities to find their way to the same endpoint but through different means? And I know you'd written about this before. I'm also curious for your take. There's a question that Ovik had raised. To what degree are these cases are the next wave of cases going to take a 14th Amendment direction or a Title VI or Title VII direction? Just very interested in your thoughts there.
Well, I've partially answered the first question. I don't think there's wiggle room at all. Immediately the Harvards of the world focused on the one line in the majority opinion by John Roberts that said, nothing in this opinion stops schools from considering individual discussions of the role that race played in terms of overcoming adversity or leadership in a community, these sorts of things. And so immediately the schools pivoted to ask questions along those lines. But then the very next paragraph or sentence after that, Roberts says, but you can't recreate through these sorts of statements or essays or any other means the same system or the same regime of preferences that existed. So it seemed like he opened the door, but then he very quickly closed it. And I agree with both of those statements. I don't want schools saying, but please don't write to us about, here's your open-ended personal statement, but don't write about issues, 1, 2, 3. That's kind of artificial. It's also might be a First Amendment problem. So I think the way that the court handled that was perfectly fine. And like I said, there's going to be future litigation where the devil is in the details. But will the focus be on the constitutional issues or the statutory claims? And the answer is both, depending on whether it's a public or a private institution or a governmental entity that's allegedly engaging in discrimination. Title VI is enjoying a bit of a renaissance. In fact, I just wrote a piece that I think is going to come out later this week in the Free Press about anti-Semitism on campus and issues of free speech, and are schools doing enough to protect students against non-speech like harassment and threats and things like this. And I think Title VI, which, just to be clear, attaches all sorts of strings and enforcement mechanisms onto federal funds. If your school, which almost all do receive federal funds, whether research grants, student loans, or otherwise, then you can make a claim to the federal government that someone's civil rights are being violated by the school. The school knows that such and such is going on. They're not doing enough to stop it. And when you're talking about actual safety, not the microaggressions and safe spaces of the therapeutic postmodern critical theory, right? And so in this, as in other areas, I think Title VI is going to be useful, and in the employment context, Title VII. It opened up a new area of, let's call it colorblind lawyers full employment act.
Yeah. No.
So this whole conference is an opportunity to disagree to some extent, and let me just disagree with Ilya here at my peril. I agree that the majority opinion of Chief Justice sort of very nearly slammed the door after saying, look, you can still use essays, right, to determine if someone has some characteristic that they've developed that's going to be useful to your campus that shows that their character is good or for whatever reason. And they talk about race or something like that. But I don't think it's a full slam. Right there, that's called his suggestion that you can still use essays to even say that is called wiggle room. There's wiggle room there, and we've seen schools immediately take up the mantle try to wiggle through the door that he's left open by saying, in my view, the unforced error. If you really care about eliminating all racial discrimination, by saying, hey, look, you can go ahead and still have these essays, right? And so we've seen them take that opportunity to change their essay prompts. Even Columbia Law School at one point had some video interview that they required, which was very clearly meant to look at the skin color of folks who were applying to their school. I think it was an unforced error to say that. On the one hand, it was never illegal to do that in the first place, right? You could always change your essay prompts or ask about folks' character in certain ways or whatever that implicate their race or implicate their interest in DEI and so on and so forth. To say that, I think, unfortunately, added an extra gloss of legal legitimacy to doing this. It was an unforced error. It ought not to have been in there. I appreciate that he said, well, still at the same time, you can't do indirectly, through essays or otherwise, that which we prescribe today or eliminating today. But that's called wiggle room. And I wish he ought not to, had done that. And on top of that, obviously, as I said in the beginning, I wish he would have said, Grutter is overturned. All right. Educational benefits of a diverse student body cannot rise to the level of compelling governmental interest, despite the fact that I do think it's logically impossible
that
for
is overturned.
That's fine. Yeah. I do agree that it's logically impossible. And for example, in a zero-sum game of admissions, you can't give a preference to one person and at the same time not give a negative to someone else. So I do think that it's sufficiently closed. But this essay thing, I mean, that's wiggle room. It shouldn't have been in the opinion.
My speculation of why it was in the opinion is because it came up in oral argument. I think the dissent talked about it. It was, because Roberts wrote the opinion, and so it's not like he needed to put that in to keep his own vote. So what, did he need to put it in to keep Kavanaugh's vote or Barrett's vote? I doubt it. I think it was just an obvious thing that came up. And yeah, it creates litigation, and it creates atmospheric wiggle room, I suppose, for PR people. But on the law, like I said, it's room for mischief, I suppose. But I don't think it's on the law, on the rule of decision of that case. I don't think it opens anything up other than, it's kind of dictum. It's kind of, has no. Doesn't change the legal rule were the opinion just to omit that altogether.
Devin, do you have a perspective on universities using targeted recruitment or funding, or there are these, there might not be wiggle room in the actual point of admission or the application itself, but my understanding is that there's actually this whole vast expanse of things that universities can do where you can just decide that if you have got, let's say, a $10 million recruitment budget, you are going to allocate the entire $10 million to a particular racial or ethnic group. Is that an area that where you foresee new litigation, or is it so patently absurd for a university to do that they're not going to engage in such practices?
It's not patently absurd. Quite frankly, I think this is the question du jour. Well, what exactly was outlawed by the Supreme Court? The Supreme Court say you can't use race in judging individuals at the decision point and admitting them to the university. Is it broader than that? Can you target from a specific zip code, for example, with dollars and cents, right, that is fungible, right? And some of it comes from the federal government, in zip codes that are 100% black or 100% Hispanic or something. It was a little bit of a thought experiment here. Is that a part of what is under the umbrella of this decision, outlawing race consciousness or race preferences in admissions? I think so, but it will turn on motive. What the motive was in doing those things and making those changes. One of the cases that is next up, and this is already being litigated. There's a petition for certiorari at the Supreme Court right now. This is a request for the court to grant a case to review, challenging the way in which the admissions process was changed at an elite public charter school in Virginia, just across the river here, called Thomas Jefferson School for Science and Mathematics or Technology or something like that, TJ for short, where the Pacific Legal Foundation took some clients and sued the school board because they wanted to change the admissions process. They didn't say that they want to admit less Asian Americans and more of preferred races like black students and Hispanic students, but at the end of the day, that was their motive. That was their intention. Their purpose was to do that, and they were successful in doing that. So the Pacific Legal Foundation sued them. It's long story short, it's went its way now to the Supreme Court. They're asked the Supreme Court to determine whether or not that's the sort of thing that is encompassed by its new announcements in the anti-discrimination space. Is that going to be a part of what's outlawed here? I think that's really the question. In my view, it is outlawed, but the Supreme Court is now reviewing that case.
Well, I think what they're going to do is they don't want to take this up again so soon, so they're going to punt the TJ suit. They're going to vacate the lower court opinion and remand it for reconsideration in light of the SFFA decision, even though that rule of decision really has no bearing on the TJ case, because the TJ case is the next step, as Devin said. But they're just going to do that to buy time, just like they weren't ready to rule on gay marriage way back when, so they came up with this weird standing decision, and so they ended up with Obergefell a few years later. Similarly here, they're going to vacate the TJ decision, which is really indefensible from the Fourth Circuit, see what it comes up in a couple of years, and then take up this next issue. But here's where I am going to disagree a little bit with Devin. I think I mean I agree that neutral-looking rules or policies that produce the same illegal race balancing and race preferences, that's not going to fly. But recruiting, I think that's something different. I think the decision points, whether for hiring or admissions, is really the whole shebang here. If you want to leave no stone unturned, especially for state schools that want representation from all over the state, and these 5 out of the 90 counties have rarely sent someone to your school, spend a lot more recruitment dollars there to make sure the smart kids are aware of, or the qualified kids are aware of their opportunities. A lot of high schools, right, the guidance counselors, they dissuade students from applying to certain places. Oh, that's not for you. That's not for us. People from here don't go there. That sort of thing. In 2023, that still goes on. And so if the UNCs and whatever institutions in the country want to do that, I think that's perfectly legal, as long as once you actually get those applications in, you're not giving preferences based on race, even on location. Depends on the size of the preferences, I suppose, and what your justification is. It can get messy, and there are always going to be edge cases. But recruitment budgets, I think, are not or should not be affected by this ruling. Now, again, policies, rules, programs. We've seen lawsuits already against law firms, for example, that have scholarships or internships restricted by race. That is not going to fly. Again, if you want to advertise these things more at schools that have a higher percentage of racial minorities or something like that, you can do that, law firm. But you can't just say, okay, this is just for these categories of people. And I think the Supreme Court is going to allow, as currently constituted, that sort of thing.
Can I just pick up here really quickly to say, look, we'll just agree to disagree on the targeted recruiting point, and maybe we'll talk about it later. one of the things I'm concerned about, though, is just sort of as a litigation risk issue. What exactly is that doing, right? What message is that are you sending to your recruiters, to your admissions officials, and so forth when you say, well, recruit in these areas because we still want to keep our diversity numbers up and so on and so forth? I think it creates a whole lot of downward pressure to continue to discriminate. We see this in other contexts as well, in employment and other spaces where when the bosses say get your numbers right. You get your numbers right. And so again, if we really are serious about this edict that eliminating discrimination means eliminating all of it that was announced in the June decision and the majority opinion, we ought to be very careful from a litigation risk standpoint, a policy standpoint, others, what messages we're sending too with some of the changes that we're making as a result of this decision.
Just one small nit here, but again, there are going to be edge cases, and yes, there are those competing cultural factors. But for example, let's say a law firm, wants to have more, white shoe, DC, New York, LA law firm wants to have more diversity, but rather than hiring someone in the 20th percentile at a top 10 school, they're going to start recruiting at Howard. I think something like that is allowed.
I disagree. But yeah, we're going to agree to disagree. One of the things that I think is really helpful to think about, again, this is on motive. It's not necessarily wrong to do that. If you have never recruited at Howard before, you've never recruited at certain geographic regions, no, that's perfectly fine. There's never been any problem with that.
Go to the first top 10 law schools. And to get their diversity numbers up, they might hire someone from one of those law schools who's a racial minority, underrepresented racial minority, who has lower grades and things like that. Instead of doing that, they're going to go to the top people at schools that have a higher percentage of minorities.
I'm really just Ilya's assistant at this point.
There you go.
Yeah.
It's great. The best kind of panel is where you get to moderate or where you really don't have to do much moderation at all. So I'm grateful to both my panelists. We do not have much time left, so I do want to throw open the floor to questions, comments, a little bit of back and forth.
Isn't there a catch-22 here with a ruling that says you can't consider race in admissions or in determining, and then on the other side being criticized or attacked for having an employment base or student base which is disproportionately white or Asian without minorities, because those cases use the numbers to determine whether you're discriminating against. I mean, that's the evidence. It's a kind of the thing speaks for itself kind of case. So you have this situation of where the employers, the universities, they're all sort of stuck in this vise. How do they get there? And maybe there are workarounds like the one you were just mentioning of recruiting from a predominantly minority school. But I've always wondered why universities couldn't just admit whoever they wanted to, let the market work out whether it's, whether that's a good practice or not. And, as long as there's not systemic patterns of discrimination against historically discriminated against groups. Leaving aside that one, why can't people just admit who they want? I mean, I know that's not where the jurisprudence is going, but I don't see how they get out of this bind.
Well, I'm a quick answer, and I'll leave the longer, smarter answer to Ilya, as usual. I agree. It should just be the folks who are the best qualified should be admitted to the university. I think there's room to have a more holistic evaluation of candidates. There are reasons why you might want the poor kid who has extra grit and extra stick-to-itiveness, who maybe has a slightly lower SAT or GPA or something like that, but is going to add something different to your campus. That's perfectly fine with me, and you ought to be thinking about those sorts of factors. But I'm no fan of disparate impact theory that just presumes discrimination and requires some sort of action to racially balance your outcomes. I'm not. Where I think it can be useful is as evidence, as Ilya was mentioning earlier, that something is afoot. Not necessarily as definitive proof that there's racial discrimination occurring.
So I have a legal answer and I have a political answer. The legal answer is the Constitution does not allow state actors to engage in racial balancing and have these racial preferences. And the Civil Rights Act, Title VI, as applicable to educational institutions, does not allow that either. And perhaps, as Justice Gorsuch wrote in his concurrence, might be even stronger on that point than the Constitution is. The political point, setting that aside, let's say there was no jurisprudence here. The political point is, in theory, the market would resolve this if the schools were transparent. If they're saying racism is such a problem in our society and the vestiges of Jim Crow and slavery and whatever else they want to say, that we are going to apply these massive preferences. And if you don't like that, that's fine. But we think as an institution that it's important to do this. If schools did this, it would be a different sort of discussion, but they don't. They say all of our students are very qualified and they're highly qualified and there's no mismatch and there's no preferences, and so that's in that sense it's a market failure because everyone, few people are saying that the emperor has no clothes.
You really need to lead off on one of these.
Sure. I have a question about the case itself, and caveat, this is something I heard on the commentary podcast, but I'm hoping you can clarify it. I thought it was, in this particular ruling, not about taking into consideration racial preferences more generally, but the very, very specific issue was these schools were putting their thumb on the scales in such a way that it was taking away opportunities from the Asian students and giving them to Black and Latino students who were less qualified. So can you guys just clarify that? Was the issue racial preferences more broadly, or that putting the thumb on the scale? Because I think that's an important distinction.
Sure. All of the above, really. So Devin got into this in his first comments. The lack of an endpoint, meaning the lack of establishing criteria that would need to be reached for affirmative action to no longer be justified. That was one thing. The arbitrariness and stereotyping. North Africans are treated as white. Afghanis are treated as white, Pakistanis are treated as Asian. I mean, all of these different, the artificiality of the Hispanic category, all of these things. Then the fact that there's no way to measure how much race is used and how it's used, the black box aspect of it, provides no way for judges to evaluate whether the school is complying or not. And there's a fourth thing. Anyway, there was four basic. Being used as negative. That's right. The zero sum issue. So those are kind of the four things why the regime failed. Grutter, remember, said that you can use race as one small factor among many and never the decisive factor. Well, nobody does it that way. That in effect is like, well, talk to us about your lacrosse playing is no different than talk to us about your ethnic community or something like that. Nobody does it that way. That was kind of an artificial standard in place. I don't know if that answers your question.
It did fully.
Okay.
I'm Candace Perucci, Utah Legislature. This is really specific, and it actually is a former life as a congressional staffer. I used to handle military academy nominations. Can you speak to this case? Does it and will it apply to our military academies? Because they have a dual mission of being obviously higher education, but also under the military. And so often I would interview fantastic boys from farm communities who, had incredible grit and worked hard to get their grades up, but were always passed over because they didn't meet a quota. So I'm just curious how it's going to impact our military academies.
Yeah, great question. I'm sorry to say there's a new famous footnote 4 now, at least for the time being. Ilya understands the other Caroline products, footnote 4. And footnote
You're really milking that.
And footnote 4 of this decision, the Chief Justice writes basically, look, this decision does not apply to service academies. They were not before us, et cetera. I've heard someone describe it as, folks who still want to have affirmative action, race preferential treatment in the service academies as sort of a carve out. But it ought not to be seen that way, and I don't see it that way either. It really amounts to a day pass. I think that's right. West Point now and the Naval Academy have been sued by the same group that sued Harvard and University of North Carolina. I think the underlying analysis used by the court to strike down affirmative action in non-service academy colleges and universities applies to service academies, and quite frankly, I think it's a bigger issue for our military. Now, I understand there are distinct considerations when you think about military and civilian life, but I think those considerations in the context of race preferences make striking down race preferences in service academies all the more important.
Just to put a finer point on it, why there was that footnote, why there was this carve out. It's not arbitrary. It's because the interest that was presented by the military academies, for example, in an amicus brief in the Grutter-Gratz cases, the Michigan cases 20 years ago, was that not just educational diversity in the classroom, but the need for a diverse officer corps to lead soldiers, Marines, sailors, etc. And so that just obviously is not dealt with in the Harvard-UNC situation. And so that's what's now going to be litigated in these pending lawsuits. We're in extra time, the red blinking light, but nobody's come to kick us out yet.
Exactly. We also started late, so we're okay.
Yeah. So we talked a lot about affirmative action from the racial standpoint. What about like SEL programming? Like, what about other? So this is like basic
Social emotional learning.
Yeah. So these are just ways, sleight of hand, to move all the same basic conceptual frameworks into kindergartens and everything else, right? So the entire discussion, how does some of those things come into play?
So these are different issues. This is kind of like what's taught and wokeism in curricula in public schools and otherwise. It's sort of part of the same larger conversation, but the legal issues are quite different, and who controls is different. It's not so much a federal government thing, although there is federal funding and oversight, obviously, but there's local control even more than state as well. Legislatures are starting to play into it. I don't know what social emotional learning even is, as distinct from kindergarten civics, as distinct from diversity and other things that are. What's that? Mark's social emotional learning is? Well, okay. My oldest is in second grade, so I guess I'm about to learn, and then I have another kid in kindergarten. So, and then 1-year-old or twins that turn 1 this coming weekend. So we're about to go through all of this stuff, and anyway.
What you'll learn is it's all being handled by Minecraft and Roblox at this point.
Devin has more social emotional wisdom and capability, so maybe he'll.
That's all true. Well, so I think that may end up being our last question. So what I like to do when I'm on radio programs and so forth is answer the question I wish was asked. And it's not going to be perfectly on point here. I think we have to remain sort of this whole thing is not over, right? And I think that was made clear by the comments that Ilya and I made on this panel. And so we have to remain vigilant, not only in suing to figure out sort of what the boundaries of this decision are from a Title VII standpoint, employment, contracting, military academies. We see quite a few folks taking up the charge there, but also in keeping an eye on colleges and universities, selective colleges and universities who have become drunk on using race preferences to racially diversify their campuses all this period of time. The Center for Equal Opportunity is doing that. It will have a hard launch on Friday with a press release announcing our After Affirmative Action Network, which will be creating a network of folks who are on the inside, administrators, faculty, students, alumni, who are taking a look at how schools are changing their admissions practices and will be not only holding schools accountable to what the Supreme Court has said now on this practice for in many different ways, but also to share best practices that schools are engaged in now as a result of Students for Fair Admission. So it's not any sort of partisan thing. It's the law is different now. Let's get it right going forward so that we're treating everybody equally and providing equal opportunity. And let's move forward smartly and not regress.
And with that, thank you, Devin. Thank you, Ilya. This was a wonderful panel. And obviously we'll be around for questions and whatnot after, but I really appreciate your time and the insights. And thank you.